Thank you for joining today's webinar on navigating the waters of a workout world, preparing for private investments that turn choppy and what fiduciaries need to know. My name is Hank Kim, and I'm the Executive Director of NCPERS. Today's program is part of our expanded Center for Online Learning. As we all adjust to the new COVID reality, please bear with us if there should be any technical issues or unplanned background noise during our session. As always, your patience and understanding is appreciated. We encourage audience participation. Please submit questions by using the GoToWebinar portal. However, to ensure that we can cover all our topics, we will hold your questions to the last part of the program. Additionally, in the handout section, you'll find a PDF of today's presentation. Our presenters today are Michael Guerin, Sonia Josephi, and Philip Guest. Michael concentrates his practice on insolvency, workouts, and commercial reorganization. His practice is broad-based, encompassing transactional, litigation, and other advice in the insolvency and creditors' rights arenas. Sonia concentrates her practice in the investment management area and focuses on a variety of regulatory, transactional, and counseling matters involving state and federal securities laws. She advises sponsors regarding the organization and regulatory requirements of alternative and private investments. Phil focuses his litigation practice on complex business disputes and his experience representing clients in the technology, energy, and financial services industry. He has served in the firm-wide management committee and as the managing partner of the Seattle office. Mike, Sonia, Phil, I'll turn over the webinar to you.
Great, thank you, Hank, for the introduction. And thank you, everybody, for joining us today for our webinar, which is Navigating the Waters of a Workout World. And as Hank said, we'll be focusing on the economic impact of the coronavirus pandemic on private fund investments, what we're seeing now in the marketplace, and potentially what may be occurring. So, like Hank said, I am Sonia, and I'm a partner at K&L Gates, which is a very large law firm. We have approximately 2,000 lawyers worldwide and are located in 44 offices around the world. As Hank mentioned, I am part of our investment management group, and I specifically work with our institutional investor group that focuses on representing all types of institutional investors and going into private funds and entering into separately managed accounts. As these are lengthy investments, throughout the path of the investment, we work with our clients and will, as needed, call on our other colleagues and other groups, which would include Mike and Phil. We call on Mike when things really go south, and I'll let Mike give a couple words about what he works on.
Good morning and good afternoon to everyone. Mike Guerin, also partner at the K&L Gates law firm. I'm coming up on my 29th anniversary with the firm, and I've been concentrated in doing bankruptcy and insolvency work throughout my career. I have represented CalPERS in the municipal insolvency cases in California a few years back, and developed a fair amount of experience, an extensive amount of experience in dealing with pension fund issues and municipal insolvency matters. So I have a deep background in dealing with those sorts of municipal Chapter 9 cases in bankruptcy parlance. I've also got a lot of history in dealing with insolvencies of various different kinds of businesses. And Phil and I have worked together on a number of cases that dealt with fraud and Ponzi activity that devolve and wind up in a bankruptcy environment. So Phil, I'll turn it to you for your introduction.
Thanks. My name's Phil Guest. I'm a commercial litigator, but I work quite a bit in the financial space. I have the good fortune of working with both Sonia and Michael in a very interdisciplinary way in kind of trying to figure out what we must do when something goes wrong. I have done work for private funds, but a lot of it is for PERS and similar types of funds, large funds like CalPERS and small down into the local funds where something goes wrong. And we'll get into that. And I think we have some interesting experiences and examples to go through. Sonia?
Okay, great, thank you. So the structure of the presentation today will first focus on what we are seeing in the market now. Next, what issues that occurred during the last financial crisis that we potentially may see resurfacing, and then drilling down specifically what happens when there is fraud at the manager, or when a manager or fund goes bankrupt. Next, how investors should react to bad news. And finally, what investors should consider doing now. So first, what are we seeing in the market? I personally have not seen any fraud or bankruptcy yet as a result of the economic fallout from coronavirus. However, there is a lot of percolation going on, and we definitely have been seeing effects of market disruption, which is going to vary based on the strategy. And I just want to point out that even though we are focusing on fraud and bankruptcy issues today, just because something goes wrong with respect to the investment program at a fund, it doesn't mean that something bad happened. Rather, that's just purely investment risk potentially. So it's really important to understand why things are going wrong. And so also we'll be looking at, I've been seeing different hedge funds restricting limitations on redemptions, which is never a good thing. And a lot of my investor clients have been getting approval requests either as a result of being on the LPAC or purely a member, being a limited partner in the fund. And I want to point out that you should pay special attention to these requests because it may mean, it doesn't necessarily mean, but it may mean that a manager is going to start engaging in risky behavior as a result of things going wrong. And they're hoping to turn things around. And so, taking bigger risk can lead to bigger rewards, but it can also lead to more loss of investor assets. Also, a request to change investment strategy, you want to pay particular attention to that because is that being used by the manager to take on more risk, and how does that risk fit within your overall investment program? And finally, thinking about any type of request to increase the use of leverage, because as Mike will be discussing, if a fund has a lot of leverage, when you get into bankruptcy, you're, as an investor, going to be much lower down on the list to recover assets. And like I said earlier, I have not seen any bankruptcy yet at the fund or manager level, but there has been a good deal of bankruptcy at the portfolio company level, which potentially is going to trickle back up to the funds in which people are invested in. So I know, Mike, you've been seeing some bankruptcy issues or have been working on them.
Yes, and so everybody, I thought when I came home to work from home that I'd have a lot more free time, but given what's happening in my world, that hasn't been the case. I've actually been quite busy for the last several months, and a lot of that is people anticipating what the consequences are going to be and realizing that there are going to be stresses in their relationships with vendors and partners, and so a lot of planning that's going on. But people understand that there are going to be consequences going to follow them. But there has been a rash of filings. The filings are up in certain industries, the kind of industries that you would expect in the current environment. So, a rash of retail filings. I think people may have tracked J.C. Penney's filed, J. Crew, Forever 21, Neiman Marcus. A lot of kind of large retail folks that people have been monitoring for quite some time, knowing that they were highly leveraged, and those have now fallen into Chapter 11. The hospitality industry, everybody's focused on that, and there have been a couple of good size Hertz filed. So rental car companies, a couple of large rental car companies have filed, and there's anticipating you'll see some more of that. Airlines, Aero Mexico just filed this week, and then people are anticipating there'll be other airlines that will file. And healthcare is another arena that people are kind of closely monitoring and realizing that there's a lot of stress in that environment. So we certainly are seeing action. To Sonia's point about the fact that we haven't seen a lot of at the fund level, or we haven't seen a tremendous amount of actual bankruptcy filings in the investments held by funds, by private funds. There traditionally is a lag, right? We usually see a lag in that kind of activity. You have a buildup and the economic recession, the recession that occurred in 2008, there was a significant lag before you saw a lot of those cases filed, and sometimes that may take a year or two to see those things actually, the consequence and the fallout occur. But we are absolutely seeing a rise in activity in the insolvency world, both on the planning side and anticipation and the actual filings. I think we're back to Sonia, is that right?
Yeah, great. So, what issues do we think that may happen again that happened during the last financial crisis in 2008? So first, what has changed since 2008? So obviously there's a different cause with respect to the economic crisis. We are currently experiencing a health crisis, and then there's the related economic fallout as a result. There is now a whistleblower program, which came into existence in 2012. I looked up, and as of 2 days ago, July 14th, the SEC has awarded $505 million to 87 individuals. So hopefully that has stopped a lot of frauds that without this program would still be occurring. More advisors are registered with the SEC as a result of the Dodd-Frank Act. And part of being registered means that you're subject to periodic examinations by the SEC staff. But I want to point out that, just because you're registered and subject to examinations, that's not a fail-safe right there. Because Madoff was registered and had been subject to a couple examinations and was never caught as a result of those examinations. There also is an increase in national organizations to help gather limited partners to communicate and coordinate with one another. I know, NCPERS is one. There's ILPA. And these organizations existed previously, but I think people really recognize the role that they play and how beneficial they can be. And I'll turn over to Mike for repeats from that we see maybe occurring from 2008.
Yeah, I think what we certainly know is that there's risk of additional leverage being created at some of the fund levels, and risk that you'll wind up with seeing instances of fraud where funds wind up being stretched and people take inappropriate avenues in order to solve financial problems. And we have certainly seen in 2008 and would expect to see again here examples of people seeking recourse in bankruptcy in order to restructure at a fund level. And those circumstances, as Sonia earlier referred to, the investors wind up being at the bottom end of the distribution barrel, and so there's a heightened risk that investors will wind up losing their investments in these kinds of circumstances. Let's see, we back to Phil?
It is me. My involvement, and a lot of this involves working with Mike either in the bankruptcy courts or in the commercial courts, has historically been kind of going back to probably about 15 years ago to instances where there's fraud or where there's misconduct. So let me start kind of by setting the table a little bit. Now, lack of liquidity and market concerns. One of the things that you will see, and Mike talked about this, is that when there is financial strain in the marketplace, when there's a lack of liquidity, think of it as the tide going out, right? Everything that's not good there starts to show, but it takes a little bit of time. Now, I put this date, December 12th, 2009. That is a typo. I apologize. It should be December 12th, 2008. my apologies, as a significant date. And I think it illustrates one of Mike's points, and it kind of demonstrates how these things tend to happen. Mike and I were involved in the largest Ponzi scheme in the Pacific Northwest. We wanted to have an understanding. We represented basically the trustee. We wanted to have an understanding of when the investors started to feel that there, or believe that there might be a concern with this Ponzi scheme. So there's the run on the bank. And what I indicated to Mike is December 12, 2008. And the reason that I said that, and I ended up being correct, was that's the day after Madoff broke. So if you go back to the financial frauds that followed, basically a lot of funds, a lot of managers, a lot of financial advisors went back and looked at their books and said, do we have anything like that? Where's our exposure? So the date of December 12, 2008 is interesting it's when a lot of things started, but as Mike said, there was a lag. I mean, this is the end of 2008, and things had been going wrong for some time. And eventually what happens is just the fraudster or the insolvent party just can't keep up. And then everybody goes back and looks at their portfolios. Let me explain a little bit about the different types of frauds. There's what you hear as a Ponzi scheme, and a Ponzi scheme is actually a very it's a very well-defined term, which is basically you attract new investors to get their money and pay old investors departing. So it works as long as the Ponzi scheme is growing and there's no liquidity issues. And a lot of funds do not start necessarily as Ponzi schemes, but they end up that way because they cannot keep the returns that are necessary to keep investors in the fund. So that's a very specific type of fraud. It's common and it tends to be the bigger frauds, but it's not the only type. Simple theft or conversion. The books are right, everything's correct, but you go and look at the accounts and the money's not there. That does happen. It's probably Ponzi's tend to be a little bit bigger because they can run for a longer period of time. But the point is sometimes a bad actor just takes the money. Promoter or manager misconduct. This is important to understand because this is misconduct that is independent, can be independent of the investments. Let's say there's a pay to play with respect to a manager. And there's some allegations that the manager may have bribed somebody either to get monies or maybe bribed a foreign government to take certain actions that would enhance the investments. It doesn't necessarily mean the money isn't there, but what it does mean is that the issue needs to be examined, determine if it worked into the investments, determine the exposure of the fund, and the manager obviously needs to be replaced. And then promoter or manager malfeasance. An example is, a lot of times guidelines are very broad, but sometimes managers go even beyond those broad guidelines. So it's important to understand that these types of issues can be a signal, as Mike indicated earlier, of potential issues that they are in essence trying to catch up with bad investments. And then the last point here before I go to the next slide is, look, it can hit in a wave. I would expect, given the amount of liquidity that's in the market right now, it might not be coming soon, but to the extent that that liquidity dries up, you could see a wave of these frauds and these bankruptcies. I think it's a good bet that you will see some. The degree, it's a little unclear. Next slide. Next slide. Great. Okay, so let me tell you, this is where we start with clients when they come in and talk to us about this, because it's important to understand with respect to litigation what your options are. And this is probably the screen that you want to kind of remember the most, is suing a fund is not, for example, like suing a public company that has hundreds of millions of dollars in D&O insurance. It is not like suing maybe a private company that has a lot of cash. The fraudsters are likely judgment proof. Insurance goes up, in my experience, to a max of $3 million and is voided, $3 to $5 million and is voided by fraud. So in other words, there is no insurance, typically private insurance, that's going to be able to pay you. Assets typically are limited. If you're lucky, the government has gone in and seized monies that are in the investment accounts that haven't been taken, and or private actors have seized those monies, so you have something to go against. But the liquidation value of Ferraris and gold bars and homes and jewelry that's pennies on the dollar. There are potential claims against professionals, auditors, attorneys, and others. A lot of times those can be pursued on a contingency fee basis to preserve funds, but those are things that need to be considered. There's potential assistance from the government. Restitution is one that is run out of the marshal's office. That tends not to return very much. Government insurance, such as Madoff, because as Sonia mentioned, Madoff had, they were part of SIPC. So there was some insurance there to pay the individual investor. But here's the important thing to understand. A lot of times when you're suing a fund, you're suing yourself. So I've had instances where people have been drawn into funds fraudulently. Blatant misrepresentation. But the issue is, if you sue and everybody else has been defrauded and sued, all you're looking to do is, everybody is basically in the same boat and there's no money. Now, sometimes that leads to what we call a series of clawback actions, which Mike and I have been very involved in, which is basically, in a Ponzi scheme, some people get out with their money and paid with stolen money, and other people are standing when the music stops. So there's an evening out process that happened, and that can, we've had, I think in Bayou, we had maybe a 50% return on clawing money back and getting it to investors that got stuck holding the bag. But for the most part, one of the main things you have to look at in your analysis is, okay, if we assert litigation, what's going to be there in the end for us? And because once you do it, all the other investors are going to do it. And I think we're going back to Mike.
Yeah, so this one Mike will be talking about when a manager or fund goes bankrupt.
Yeah, so this would be the consequences when things really get bad, and when some things that Phil has just talked about come to light. Many times the consequences that either the fund or the investments in the fund will wind up in bankruptcy. But we'll focus on the fund filing. What happens in bankruptcy, the purpose of a bankruptcy filing really is to restructure the financial affairs of the bankrupt debtor. And there's going to be a revision of the capital structure of the fund in the bankruptcy case. And generally what that means is there's going to be either mostly an elimination. I mean, most of these cases really, frankly, Chapter 11 cases these days are liquidations. And most of the time the assets are being, sold off, and then there's a limited amount of cash that gets paid out, and the equity interests really don't see a return. In really very, very, very few cases do you see a return to equity. So there's going to be a significant impairment of equity at a minimum in a restructuring, in a Chapter 11 restructuring, but under most circumstances, equity is going to be eliminated. In bankruptcy, what the process in bankruptcy, there's a plan that gets proposed. There's a kind of two-step process of a disclosure statement that lays out what the terms of the plan are going to be, and then balloting, where people vote on the plan, and then the plan gets confirmed with a court order that says, it's approved by the court, and there are some consequences of that. And one of the consequences is that the debtor then gets a discharge of certain creditor claims. And among the discharge claims would be the claims that the investors would have generally against the fund. And most of the time you'll see in Chapter 11 cases provisions that also protect management, discharge claims against management, and potentially other parties. And those are, there's some controversy about whether those are, there has to be a quid pro quo for those. Sometimes they're framed as a settlement with the investor class, with an opt-in provision where the investors have to, elect, to grant these kinds of releases to management in exchange for releases of the investors of claims that could be brought against the investors. And so, but these plans are traditionally proposed on terms where you're going to wind up losing the claims that the investors might have. And so it's important when a bankruptcy case gets filed from the investor perspective to pay close attention and to get on top of that process. The process can be very fast-paced. We've seen Sonia and I and Phil and I were involved in a case that was a prepackaged plan that was filed for a fund. And a prepackaged plan is, the negotiations with the secured creditors and many of the larger unsecured creditors have all taken place pre-bankruptcy, and they've got a package with a plan that's already created on the day they file, and then they run this through the plan confirmation process in a couple of months, 60 days, 30 to 60 days for a prepackaged plan. So when a case gets filed, you need to be immediately on top of, what the issues are that are being presented, what the timeline is, what the consequences of the plan proposal are going to be on the investment group, and you got to be able to react to that and understand what your rights are in this bankruptcy context. Sonia, next slide, please.
Hey, Mike, can I jump in here for a sec?
Please.
So when one of the things that people may be thinking when they're looking at this is, well, if the equity doesn't get any money, we're always the equity because we're always the investor. And the one exception that I've seen in my cases is when there's a fraud and you're induced by fraud to invest into a fund, you have a rescission claim. And that basically, that makes you more than just an equity investor. You actually become a creditor. Now, it doesn't solve all your problems because you're subordinated to a lot of other creditors, as Mike will go into. But there are instances in which you can convert your equity position to a creditor position, but you're converting it with everybody else who invested in the fund. That was my only point.
Yeah, I think that's a fair point, Phil. And I think the idea that you could be construed as a creditor, that could be of value to, not necessarily in bankruptcy, because as I think you refer to, there is a specific provision in bankruptcy that subordinates claims, rescission claims, on account of an equity investment to an equity position. So now there's some limitations on that, and there may be some avenues that you'd have a window to pursue a creditor claim, but in most circumstances, your equity investment is going to be subordinated in a Chapter 11 case, even if you do have a creditor's rights base claimed.
Yeah, and our issue that we ran into on the East Coast was they tried to get the bankruptcy dismissed by saying there were no creditors, right? They said all the trade creditors have been paid, there are no creditors, you dismiss the bankruptcy. And so we had to demonstrate to the court, no, we've been defrauded, therefore we are creditors. But you do sit very low on that list. And that's when I go and I stand in Mike's office and say, what does this all mean? So.
Well, I mean, one of the key takeaways here is, and it is possible to salvage some value in this Chapter 11 process. There are circumstances in which there are assets that are available and distributions that can be made even to the equity level, and there can be negotiations. And this plan process and what happens in bankruptcy is really a collective negotiation process, and it is understood that the constituents are all going to step in and are going to have open sharing of information, and that's one of the benefits of being in bankruptcy is you get this ability to obtain financial information on a free and open basis, and that you have an ability then to negotiate for some kind of treatment under this plan that will either salvage some value or at least eliminate risks of investors through that process. Phil kind of referred earlier to this notion that there couldn't be these clawback claims, and there are avoidance action claims in bankruptcy that a bankrupt debtor or a trustee succeed to, and those are really creditor rights-based claims that allow a debtor in possession or a trustee to come back and recover distributions that were made to investors or to creditors in this insolvent time frame. And those claims create a significant risk for investors, and those claims can be negotiated to eliminate those risks of those sorts of claims being brought back against investors in exchange for example, granting releases to other parties in the case. So that's the kind of thing that I think is possible through this plan negotiation process. And another reason, one of the reasons that it is extremely important to engage with counsel in order to engage with the other constituents in the case, to evaluate the opportunities and the risks in the case, and then try to negotiate a favorable result for the investor constituents. Next slide. I think I've already talked about the avoidance action issues. One of the things we've focused on is making sure that the investor's board is fully apprised of the consequences of bankruptcy filings, and that communication process is very important in order to have an informed basis for making decisions about what path you might want to take in this bankruptcy process. And so having knowledgeable bankruptcy counsel and fund counsel and litigators advise about what the consequences of the filing are, what the risks are, what claims you might be giving up if you agree to certain releases in a bankruptcy plan, what the value of those claims might be as compared to the benefits that you're achieving out of the bankruptcy case through, for example, releases of these potential avoidance action claims. It's quite important, and it's extremely important then to keep the board informed so that the board can make a reasoned decision about what path it wants to take. Next slide.
Okay, and I'll just point out too, this is Sonia, and I'll just point out that, even if you are giving up certain claims for the bankruptcy filing, it may not matter, because if you're in bankruptcy, potentially that means that there are no assets left to recover. So there's no point in pursuing claims and spending a lot of money doing that if there's nothing there.
Yeah, I think that's a fair point, Sonia. We should talk about, the priority levels in bankruptcy and the way things get distributed. Bankruptcy has a strict order of priority in the way assets get distributed. Secured creditors get paid first. To the extent they've got collateral, they get paid from the basis from their collateral. And most of the time, the a senior secured lender has an all assets filing, and so all of the assets are encumbered, and so the secured lender is going to be paid first and in full before any junior class of creditors can be paid. And then there are levels of priorities: administrative claims, the claims of the professionals, and the operational expenses of the bankrupt debtor get paid as a first priority. And then there are certain unsecured priority claims, wages, taxes, those kinds of things that get paid before general unsecured creditors get paid. General unsecured creditors get paid, and then last, equity gets paid. So that priority scheme, is what leads to commonly a result where equity would be left out with little or no distribution coming out of a bankruptcy process.
And just to point out, before we move over to Phil, which is that equity holders, which are the last ones, would be the investors in the fund. And so Phil, I know you're going to talk about tools that investors have to work out issues.
Yes, and this is, you know, I identified the one slide that was important to remember. The fact coming out of these next slides that is important to remember is if you see a problem or potential problems, act. And I can't overemphasize this. I mean, the example that I like to give is had a manager, small city-based retirement system. All of a sudden, that manager noticed that we had an investor. It was a PERS that had noticed that the manager had taken about $300,000 and put them into unrated Native American bonds in North Dakota, an investment that was outside the guidelines and didn't make sense. You know, the manager and I talked. The first thing the manager did was get the assets liquidated from that manager, the $5 million. Within the next 60, because you know, if somebody's going to go that far outside the investment guidelines and just not be able to explain it, you know, that is telling you something. What ultimately happened is over the next 60 days, the manager, this is the Atlantic Asset Management scandal, stole about $40 million. So, you know, the quick action of saying, this doesn't look right to me. I don't know this new person who's taken over. I don't trust this new person. That really kind of saved the day. So you know, that would have been a $5 million loss that turned out to be a $300,000 loss. So one of the things, and I think Sonia's really good at this because I've worked with her on it, is, you know, fact-checking rosy claims by a struggling manager, by a manager that can't provide good explanations. If the explanations seem suspect or don't meet kind of the common sense guidelines, you should be cautious. The second issue is kind of check with counsel and experienced counsel that's dealt with this. Look, you're not committing to filing a huge series of litigation or spending a whole bunch of legal fees. What you're doing is trying to address issues right as they come up and put yourself in the best possible position. You know, it is unlikely, for example, when you have a struggling manager and the fund's going down, that there is no fraud, that it might be a bankruptcy issue, maybe the fund comes back. But it is not very expensive, and it is always good to act first and not let things get worse, because if there is a problem in the fund, whether it involves intentional misconduct or not, those problems rarely get better with time. The other issue that's very important is, you know, take advantage of the privilege. The attorney-client privilege is out there so that people can have clear and candid communication about what people knew and what happened. And in this space, not as much with the PERS, but maybe with the private funds, there are people who say silly things in emails that are flip and many times not factually accurate and can compromise people's position. Oh, I always knew this was an issue, or this isn't a big deal to us, et cetera, et cetera, et cetera. So one of the things is to make sure that you're keeping your internal communications confidential to protect your legal interests if you want to go back and recover these monies. So, you know, if you're taking away from one thing, it's, you know, pick up the phone, call an experienced counsel, talk through the issues, work your checklist. Next slide, sorry. Then, you know, going through, and typically I do this with Sonia, is you know, go through and find out what information rights you have and what redemptive rights you have. it never hurts to figure out your options a little bit ahead of time, even if you don't exercise them. A lot of times, this is something that I've seen work relatively well, particularly when there's manager misconduct that doesn't relate to the overall investments. Let's say it were an instance where a manager engaged in illegal conduct unrelated to the fund. You can get information, you can get the manager replaced, and you can, most importantly, preserve the value of the assets that you have. Looking at special redemption rights, understanding what those are in advance before things get too bad is really important. I mean, Sonia, do you have anything to add to that? Because that's really where I come to you and kind of say, what can we do here?
Yeah, I'll just move on to the next slide because I know we're starting to run out of time here. Is that, it's really important to look at the documents and know what your rights are under the documents. So for example, our first bullet point on this slide is to seek out other investors in order to collaborate with them, because it's always power in numbers. So you need to make sure that you have a right to know who the other investors are, which would either be through your partnership agreement or a side letter. So that's something just to think about going forward when making new investments. And then I'll move on down to the next bullet point here for taking collective action. And this is a good idea to work with other investors when something bad happens. Because you should all have the same common interest, since it's all your money that's being invested. It's going to lead to reduction in expenses. And at the end of the day, the documents, when I have worked on issues where bad things have happened, usually just serve as a roadmap and a guide. And they're not necessarily followed because, and sometimes they don't work in the situation, because it's impossible to draft a document that is going to address every situation that arises over the next 10 years. And then Mike, do you want to talk about bankruptcy filings?
Yeah, I mean, I think it's a follow-on to your collective action piece. And, one of the things in bankruptcy I think I referred to earlier is you do have these broad discovery rights, and there's a culture of sharing information. So you have an ability to go in and obtain information about, what the past history's been, and explore, if there's been fraud or there's been illicit activity, you can document that, and you can then evaluate what rights you may have that result as from that fact investigation. And then you've got a right in bankruptcy to do formal discovery that's very broad if you can't get informal discovery. The other thing you wind up in bankruptcy with is a right to, in many cases, you can get an equity committee appointed, and that is a collective, that's a group of equity investors that have standing through this committee to appear and be heard in the case. And the expenses of legal and financial representatives for that committee would be paid by the bankruptcy estate, so it's not being paid for individually by the equity holders. So there's a significant advantage in doing that in bankruptcy, and that ought to be considered. Equity committees aren't always appointed, but that is something that ought to be considered when a case gets filed. Phil, you have thoughts as well, I think.
Yeah, and I'm going to talk about the government. I've been involved with enough of these so that Mike and I have actually had some experiences with the government. There are various government entities that can help or may not be that helpful depending on the case. The SEC does a lot of the civil enforcement, and a lot of times they may get involved and create a receivership, and that can have some benefits. The DOJ tends to pursue the criminal charges. They are generally looking to convict the fraudsters, and recovery of money isn't something that they work with generally. They do get restitution, but sometimes these federal agencies have the ability to seize assets in advance. So if there's misconduct you find about and you think the assets may run, it might be good to go to these people. The other probably underutilized asset is state AGs. There are a lot of very good aggressive AGs in the country: New York, Minnesota, Washington State, California, I'm sorry for the ones I've left out. And if, for example, you are in that state and you are a PERS fund, that may be an avenue where you can really save some fees and get them to help pursue remedies for you. There's the Marshal Service, and they do asset seizures and restitution. Sometimes if there's some assets there, I've seen instances where they've been able to seize sizable investment assets that were about to go overseas, and they could distribute them. Typically, it's the gold bars and the Ferraris and the houses. Next slide.
So,
go ahead.
Let me say one quick thing. My experience has been that the agencies, the government agencies, actually want to defer to private trustees, and if there's a bankruptcy case in place, for example, they're absolutely going to let the asset recovery and distribution take place through the bankruptcy process rather than through the marshals going out and seeking recovery for restitution purposes. They do, as Phil said, they want to focus on the criminal actions. There are SEC receivership cases, and the SEC comes in and they will appoint a receiver to take the business over, and that's kind of an alternative path to doing a Chapter 11 bankruptcy filing, and those can operate like a Chapter 11 case, and you can see distributions through really a private receiver that gets appointed by the SEC. But the most effective way to get recoveries is not going to be through the government. Frankly, it's going to be through some private receiver, trustee type that has experience in how to go collect these assets, reduce them to cash, and distribute them.
Yeah, and I would only add in, this is the bankruptcy and the commercial litigator kind of going back and forth, but we do this all the time. I would add in that overall it is, I've seen the SEC receiverships work pretty well, particularly when there aren't a lot of assets in the fund. Atlantic Asset Management, I think, did that, but there was really no recovery. The one exception, and I generally agree with Mike that waiting for the government doesn't, you've got to get through people and get people to act. The one exception is, I would say, is if you think there's a fraud and there's money running around, the government can be effective in seizing assets. In Bayou, they seized, money was about to go overseas in Arizona, and they ended up seizing it. And that was it was $108 million, and that was very beneficial for the shareholders. So as a general proposition, I agree the government sits back and they're worried about putting people in jail, but there are times when they have the tools that can really help. Next slide. Okay, so I think, one before.
All right.
So I'm going to go, this is redundant, but it's important, so I'll go over it quickly. Look, quick assessment and actions. You got to protect the existing assets. You have to determine an interim strategy. There will be no final strategy when you're coming out of the blocks. Just an interim strategy, because things are going to change. You're going to collect your facts and protect communications. Next slide. And here's why. And you have to adhere to your fiduciary duties and make sure that members and investors are adequately informed. You have to be able to do your due diligence and keep, for example, the board informed of what's going on. But the other simply is PR. I mean, if this is a public scandal, the Sacramento Bee or the Seattle Times or the New York Times or the Chicago Tribune are going to call and say, what was your involvement in this? And you want to have all the, and not having an answer is not a very good answer. You want to have as many facts as early on as you can. You want to make sure that you're not saying things that are factually inaccurate. Everybody needs to get their story straight. And then obviously there are regulatory issues that can follow on as a result of these actions.
All right, yeah, and move on to the next slide for fiduciary oversight issues. I know we touched on this already, but it's very important to raise critical issues with the board and keep them updated. You never want your board to find out about something in the news or at a question at a board meeting with respect to one of the investments when they should have been informed in advance. Also, the board is a fiduciary. Generally, they're subject to the prudent person standard. So you want to make sure there's appropriate documentation there for the board to fulfill that duty. And this is where you could use in-house counsel or a third-party law firm to draft a memo when something bad happens, whether it's fraud or, you know, there's a lot of investments that are losing, you know, their asset levels, or if there's bankruptcy, so that you can assess the facts, lay out the options for the board as to what direction to take, and then show that there was consideration of the different options and, you know, provide a justification for the path that was taken. And then, you know, finally, our last topic that we have for today is what should investors consider doing now? And so one thing is, you know, open communication, which is extremely important given the economic situation and the fact that everybody's at home right now, or generally is at home. So you want to make sure there's regular communication with the managers and that there's, you know, avenues to communicate internally, because you're not going to be, say, you know, walking down the hallway and seeing your coworker or stopping in someone's office, just if everyone's at home. So you want to make sure that there's open communication among the investment staff, as well as internal counsel and key officers. And again, keeping the board informed is very important. And finally, given the stay-at-home order, you want to review your due diligence process. And, you know, in particular with respect to any of those LP or LPAC approvals, and particularly for those amendment requests. You know, make sure that there's a process in place that it's getting in front of who needs to look at it and sign off on it, which should include your counsel. And then, you know, it's really important to keep doing diligence. Even if you're at home, you need to continue doing diligence for your current managers and think about how you can do appropriate due diligence for new managers. And this is not a one-size-fits-all formula. It's going to vary based on the facts of your plan, types of investments, size of the staff, and, you know, what the board's role is and how actively they are engaged. And finally, evaluate how you can be nimble by working remotely. So, you know, like I was saying earlier, you want to have a memo if something really goes wrong, but you want to make sure that in order to write that memo, you have the documents there and that you have a good document retention program still in place when people are at home. And finally, you know, would forming a board subcommittee help? As Phil talked about, you know, and Mike as well, you may need to react very quickly. So we have some clients who have formed a board subcommittee that are certain members that they know can get on the phone very quickly and discuss an issue, because time may be of the essence. So that I will end, and thank you again for joining us. We are going to have question and answers now, but if you have any questions that come up in the future, feel free to reach out to any of us. And I think our emails are on the second slide.
Great, Sonia, Mike, Phil, thank you so much for that great presentation. I know we are a little short on time, but let's address one question. So I think, Phil, you were the one who raised the very sage advice of keeping the board informed when investments go south. But do you have any advice, or how do you counsel your clients relative to how proactive they should be in informing the media, the public at large, and beneficiaries and plan sponsors?
Yeah, that's really a great question. And I want to kick it over to Sonia after I provide my answer, because the answer is it's complicated and one size does not fit all. And that you need to be, obviously, sometimes it's going to implicate attorney-client privilege. So I would say to figure out a strategy on that, there's going to need to be a lot of communication. Sometimes, for example, communicating with the media is it can be a good thing, getting out ahead, and you know, particularly if it's already in the public sphere. In another times, you know, sometimes papers write just what they write, so it's better to wait for their call. So I don't have a one size fits all, but I think probably, I want to kick it over to Sonia, see what she has to say, but I think speaking with your board and taking the temperature of your board and understanding the community that you're in is really important. Because, if this happens in Omaha, it's a really big deal. But if it happens, say, in New York, it may not catch as much of the news. And so you kind of have to vary your result. I wish I could give a more one-size-fits-all answer. Sonia?
Yeah, I completely agree with Phil that it's not going to be a one-size-fits-all. And, other factors to think about is, what is the level of loss or losses? How many bad acts are you encountering with respect to your investments? Because say if there's repeat fraud and repeat bankruptcy occurring with all your managers, then it may be time to, reconsider some of your diligence processes. Bad things happen, and that's just a fact of life. But if they keep happening repeatedly, what really went wrong there behind the scenes? And how do you approach that with the public is going to be really important too. I think it's also, like Phil said, I'm in San Francisco, so I know the public reaction in San Francisco is very different than other parts of the state or country as well. So it's all these different facts and circumstances that come into play. The most important thing for a media strategy, though, I would say, is to have one consistent story, so you don't have a bunch of different ideas or issues floating around that just leads to confusion, and really show that you're proactive on top of any issues that have gone south.
Great, thank you, Sonia, Phil. Mike, we have a couple minutes. Did you want to add anything?
I think those guys have said everything I would say, so I would not be redundant there on that question. And if you have other questions that more relate to the bankruptcy issues, I'd be happy to weigh in on those.
Okay.
But
well,
as the litigator who can't stop talking, I will add in one thing. In coming up with these strategies, talk with a lawyer who's experienced in this space. Okay, have a litigator involved and have a bankruptcy lawyer involved. You don't need to have 3 lawyers on the phone, but don't talk to somebody that may have helped with a commercial litigation case and doesn't have experience in this case, because they're kind of a unique animal and it takes collective thoughts. Sorry.
That's the first time Phil said that in 20 years of practice, the first time he's given credit to the bankruptcy guys. So
that's because I hate that.
Michael, Phil, Sonia, thank you so much for your wonderful comments today. And to our audience, thank you for joining us. The Center for Online Learning will go on hiatus for the balance of the summer. We will return with new and timely webinars in October. Thank you all and have a good and safe summer, everyone.